All right, you aspiring attorneys, legal pundit wannabes, future judicial appointees, and inevitably, those of you who will be selling cars in a couple of years. I'm William Barr, the Attorney General of the United States and de facto lawyer for the President. You are part of a select group who paid $5,000 for the honor of attending this lecture. When I am finished, you will have everything you need to take the upcoming bar exam and practice law in Washington, D.C. And if you fail to pass the exam, well, we'll probably have something for you at the White House. Rudy Giuliani is always looking for someone to keep track of his dentures. Okay, enough with the pleasantries. Let's get down to brass tacks. You want to be a lawyer. You want to be a winner. And to do that, you must not only know the law, or at least have a passing familiarity with it so you don't get a surprised look on your face when someone uses a legal term, but you must project the right attitude. Attitude will get you further than any legal hornbook. Alright, since those other prep courses go over the basics, consider this the advanced course. I'm going to tell you all the important stuff the other guys are ignoring. First, contracts. They will tell you that a contract is an agreement between two parties where there is an offer and acceptance with a meeting of the minds about the content and price. Here's the real truth. Until you've paid, the contract is always negotiable. The price is never the price. In fact, the longer you can drag out the payment, the lower the price you'll have to pay. And if they were stupid enough to do business with one of your shell companies, make sure it's a paper company with no hard assets. That way, they won't be able to get something if they sue you. Next, evidence. I'm sure you learned the basics about laying a foundation, objections based on hearsay and relevance, yada yada. Here's the most important term you need to know. Executive privilege. If you are in a position of authority and answer only to the President, this little beauty is a one-size-fits-all legal Swiss Army knife. You can use it to ignore subpoenas, withhold documents and witnesses, and in some cases, even fire the people prosecuting you. It's awesome. The most important thing about executive privilege is it has to be invoked summarily and unequivocally. Under no circumstances can you waver. Being condescending and hubris are your allies. Rolling your eyes at Congress is a good example. I once told Chuck Schumer to eat my shorts. Man, that felt great. Next, civil procedure. This is about knowing the rules, making sure parties receive notice, that you have jurisdiction. Now, here's the reality. If you are in federal court, like I always am, it doesn't really matter, because your boss appointed the guy who's presiding over the case. Therefore, you can do pretty much anything you want. Now, you'll have forms for the day-to-day bullshit. No need to use your advantage all the time, just when you need it. That way you can claim you're impartial. The other thing you'll need to do is file briefs. This is where I recommend the summary. That's right. Instead of writing a whole brief, simply summarize your case for an already sympathetic court. That way, you'll have to do less work and you can omit the less compelling facts. As a bonus, don't be afraid to use the redaction tool. Handing in a summary report filled with redactions not only lessens the actual writing you have to do, it will give the judge the notion that the case is extremely important and involves highly confidential materials, making it much less likely that he'll question you. So remember, redaction is your best friend. Finally, it would not be fair to you if I didn't leave you with this one final bit of advice that comes from my many years of practicing law and serving the President. Before accepting a job, above all else, make certain you have a pardon signed and securely locked away in your safe deposit box. Thank you for attending, and remember, the future is in your hands. Make sure you get a piece.